Good morning, everybody. My name is Betsy Falkoff, and I am an associate in Cummings & Lockwood's Private Clients Group based in the Stamford office. Today, I'm going to be talking with you about estate planning for young adults when they turn 18. So here we have Kylie Jenner on her 18th birthday. I'm assuming Kylie had a pretty extensive estate plan when she turned 18, considering she was worth somewhere around $1 billion. But even for our more normal high net worth clients and families, when a child turns 18 and becomes a legal adult, families are presented with an often overlooked great opportunity to discuss future planning with their now adult children, introducing them to family attorneys or financial advisors if it's appropriate during this normally really exciting time in their lives. When estate planning for young adults, there are three primary purposes. The first is incapacity planning. The second is to allow for management of assets during the adult child's lifetime through the use of a revocable trust. And the third is to provide for disposition of assets at death using a will and a revocable trust to avoid the application of the laws of intestacy, which we'll talk about a little bit later. In Connecticut and many other states, when a child turns 18, the parents no longer have the ability to make financial or healthcare decisions on behalf of their adult child or access that child's medical information. When discussing incapacity planning for young adults with your clients, the important questions to ask are first, who will have access to the child's accounts or their assets if the child is incapacitated or unavailable? And who will make the medical decisions for the adult child if the adult child is incapacitated in a medical emergency? There are three documents that we use that many of you are probably familiar with in incapacity planning. The first is a power of attorney. The second is a healthcare directive, and the third is a HIPAA authorization form. So first we have a power of attorney, which normally for young adults turning 18, we would name their parent or parents as attorneys in fact to manage that adult child's assets in the event of incapacity, although the document is effective immediately upon execution. Second, we have an advanced medical directive, which includes two main parts. The first is the living will, which identifies the adult child's wishes as to life support measures in the event they are terminally ill or permanently unconscious. And the second part is the appointment of a healthcare representative. And that would usually name a parent or parents as healthcare agents to make healthcare decisions for the adult child in the event the adult child is unable to do so for themselves. And last, we have the HIPAA authorization form, which ensures that parents acting as financial attorneys in fact and healthcare agents can obtain their adult child's protected health information to make decisions regarding that adult child's care. An important question that might come up when you're discussing estate planning for young adults with your clients is whether these documents, these incapacity documents, should be established in the child's home state or in the state where they're going to live to start a new career or attend college. Generally, these documents remain valid even if your adult child moves to a different state. However, if the adult child is attending college in a different state, you may want to suggest that your client check with the specific university to make sure that the school does not have a specific form it might require to be used for parents to access an adult child's medical information, for example. If the adult child is moving to a different state to start a career, the incapacity documents should be established under the laws of the child's new residence state. Here we have some topics that you might want to consider when discussing estate planning for young adult children with your clients. Especially in recent years, teenagers and young adults are increasingly engaged in digital entrepreneurship, whether it be as a social media influencer or involvement in an e-commerce business. If successful, these businesses could have a significant value and require more sophisticated estate planning. Our documents always include the necessary digital asset language to allow fiduciaries access and management to these assets in the event of incapacity or death. You might also suggest to your clients that their young adult child prepare something like a digital asset inventory list, which would list all of the platforms, the use of each, and the passwords. Obviously, the young adult child doesn't need to share this with their parents, but it would be accessible in the event of the adult child's incapacity or unexpected death. When planning for distribution of assets at death, as I'm sure many of you are familiar, there are two documents that we use, a will and a revocable trust. For a young adult child, we would name the parent or parents as executors and provide for the disposition of the adult child's assets at death, usually among surviving siblings if the child has no children. The use of a will avoids the application of the laws of intestacy. In Connecticut, if an adult child dies without a will, with no spouse and no children, their assets are distributed up to the surviving parents, which would cause any gifts made to that adult child by their parents to become the parents' assets again, and cause those assets to be includable in the parents' estates for estate tax purposes. So this is something obviously we would want to avoid. Next, we have the revocable trust, which would be used in conjunction with the will to provide for both management of assets during life and disposition of assets upon death. Similar to the will, the revocable trust would name a parent or parents as a trustee and would be solely for the adult child's benefit for their lifetime, revocable by the adult child with the agreement of a co-trustee, which would normally be a parent. The revocable trust would provide protection of assets from outside influences during the child's lifetime and can name a co-trustee until the child attains an older age and is capable of handling their assets on their own. One of the primary advantages of funding a revocable trust for a young adult child is to delay the ability of the child to have unfettered access of their funds beyond the age of 21. And we'll discuss this in a little bit more detail in a second. Upon death, for example, if the adult child has descendants, assets can be held in continuing trusts for the benefit of the adult child's children. If the child doesn't have descendants, similar to the will, the revocable trust could provide for distribution to siblings. So there's a lot of flexibility in terms of distribution options at death. The most common initial funding of a revocable trust for young adults in our practice is money from a UTMA account upon termination. All of these items listed on this slide could be sources of initial funding for an adult child's revocable trust. We're going to talk a little bit more now about UTMA accounts, terminations, and planning opportunities. When an adult child attains the age of 21 in Connecticut, New York, and Florida, with some caveats, the adult child's UTMA account terminates and the adult child becomes entitled to the funds outright. When your client's children turn 21, the question really becomes, are they capable of managing and protecting potentially hundreds of thousands of dollars, or are they more likely to spend that money on skydiving trips, expensive cars, who knows what else? So upon termination of a UTMA account, you're presented with two good planning opportunities. The first is when the adult child turns 18, Connecticut General Statute Section 45A 558K allows the custodian, which is normally the parent, to assign the assets of the UTMA account to the adult child's revocable trust as long as the statutory requirements are satisfied. The statutory requirements include, first, the parent or custodian has a good faith belief that the distribution to the adult child's revocable trust is in the adult child's best interest. And second, the adult child must be the sole beneficiary of the trust during his or her lifetime. This is not a gift, can be done without court involvement, and will terminate the UTMA account to the extent of the property that's been distributed. The second option is to wait until the adult child turns 21 and have the adult child fund their own revocable trust themselves. It's a good idea either way to set up the revocable trust along with the other estate planning documents that we've just reviewed at age 18 so that everything's in place when your clients are ready for termination of the UTMA account and/or funding of the Rev Trust in the coming years. Well, that's all I have on this topic, and hopefully this has given you something to think about with your clients. And even if your client isn't a Kardashian, these are topics that your clients should be discussing with their children and with their families. Thank you.